after decade, this body of jurisprudence.
The right to access to navigable waters that presumably do not enjoy the same status in that hierarchy of rights as the Common. Is that your position?
In these safe schools, those were constitutional. And so there's not, those are not fundamental rights in the same way the liberty guaranteed in Article 1 is.
But Mr. Jones, so is there a difference between inalienable and fundamental?
Inalienable was used by our drafters of our Constitution because fundamental rights were no longer, were not yet recognized in the lingo of constitutional law. We would suggest
is the essence of your argument that the people have a right to amend their Constitution unless they do it in a way that the Supreme Court really doesn't like?
no, absolutely not.
Well, how's your argument different?
We would be asking this court to, we are asking this court to strike down Prop 8 because it violates Article 1, Section 1. But it's not whether this court likes it or not, because I'm sure, there are existing ways in which this court strikes down constitutional amendments.
Yes, one is to call them a revision, but apparently this isn't a revision in your judgment. So how do we determine which amendments are okay, since you're saying this is an amendment, in which the people have somehow given up their right to engage in it?
And you may respond to that, but your time is otherwise up, Mr. Kruger.
I think that's a good question before we answer. You would look at, this court has already said that liberty in Article 1, Section 1 protects the right to marry for gay men and lesbians. And therefore, in this particular case, and I wish I had all the morning to talk about this, Justice. In this particular case, there's no compelling reason, there's no compelling justification for this initiative, and this initiative amendment and Proposition 8 should be struck down for that reason. Thank you.
Thank you, Mr. Kruger. We are now from Mr. Starr.
Thank you, Mr. Chief Justice, and may it please the court. In light of the colloquy just now with General Kruger, in light of the extraordinary body of this court has developed over literally decades, is so stable. It's so beautifully developed. It's one of the reasons, as the court noted, that courts around the country look to this court, and rightly so, with respect to this among other bodies of jurisprudence. The body of jurisprudence here includes the proposition that the right of the people is inalienable to control their constitution through the amendment process, and that's been the case, and this is where the Deputy Attorney General agrees, since 1911. This was not...
I think that's true. I don't even think it's in dispute, and it's a wonderful attribute of our government. I'd like you to address what I know you're going to. Why is what transpired here an amendment, which the people have the right to do, or a revision, which the people also have the right to do, but by a different procedure? Why is this not a revision? Not only because the past language that we've had, which talks about the structure and the architecture of government, but because of the, one might argue, far-reaching implications of taking a suspect class and removing from them certain protections. So why is this not a revision?
To embrace the rule, if that were the rule, would be an unprecedented revolution in this court's jurisprudence.
The rule that altering fundamental rights of a protected class. Well, in case it's never come up before.
It has been I agree. The precise issue, because of the suspect classification has not been before this court. It's had some very close analogs. And when you look, and you've favored counsel with a number of quotations from this court's jurisprudence, when you look at that jurisprudence, and I would begin with Amador Valley's looking back on Livermore v. Wade. And then as you trace the case law through, Legislature v. Lulu, the Ray v. given case, a wide variety of cases, it comes down to this. This is the law that the people of the state understand. It's been articulated by justice after justice with a remarkable degree of unanimity. This court on this issue, even though it has split on other issues in the arena of was this a proper amendment, the single subject rule and the like, this court has been unanimous in saying, unless, Your Honor, it goes to the structure of the government, not to rights. Very important rights have, in fact, been either taken away or dicta, such as in the Amador Valley case, noting the possibility that there could, in fact, be the structural change of what? A shift of the judicial power to the legislative branch.
Well, let me put your theory to this test. Let's take something that would arguably certainly be a non-governmental structure in nature. Let's just say there was a very specific amendment that deleted the right of free speech from Article 1 of the Constitution, period. Nothing to do with governmental structure. Is that something that, because it doesn't deal with governmental structure, you feel could be accomplished by way of amendment, or is this such that a revision is required?
Well, first of all, it would, of course, be dead on arrival under the federal constitution.
Right. A lot of things would, but we're just, of course, confined here to the state.
Yes, but the hypothetical doesn't.
Or it wouldn't be dead. What would happen is, arguably, it would be dead under the state jurisprudence, but there would be protections extended under federal constitutional law that would take care of it. But there's nothing in the federal constitution, I would posit, that requires a state to have in its own constitution a First Amendment equivalent.
Quite true, but because, and again, I don't mean to quibble with a hypothetical and I will treat it, but because of incorporation, we all enjoy as citizens of the state, but also we're citizens of the United States, so we do enjoy protected rights to free speech. Even there, while it is unthinkable, and that's one of the wonderful things about the amendment process and the initiative process, most don't make it through. That would not get the, but let me deal with the hypothetical under our theory.
But Council, don't we start with
rights? That's the nature of the consent of the government.
So,
It's
Mr. Starr,
unthinkable, but
given your response, does your argument here, and I think the answer is going to be no, depend on the theory that's been advanced that Prop 8 only affected the nomenclature of the relationship between gays, as opposed to taking away domestic partnership rights or all the other governmental respect given to the personal relationships. So your argument does not depend on the fact that only the nomenclature. Your argument what about Roe versus Evans, where people of the state of Colorado, by initiative, passed an initiative saying no anti-discrimination laws.
Just the beginning, baby. When is it over? When is it over?
Well, oral arguments are underway right now in the California Supreme Court behind me. 7 justices